States Constitution, the Kansas Constitution, statutes passed by the Kansas legislature, or court decisions. That law frames our decisions in these appeals. We don't evaluate whether the law is good policy. That is the job for the legislature and the executive, the governor or your local commissioners. Our obligation is to set aside politics, special interests, and even public opinion. That means, for example, that tonight we will not do a public opinion survey or ask you to tell us how you think we should decide these cases. We must remove ourselves from all of those influences because our job is to maintain a fair and impartial court for all. For as Thomas Jefferson said over 200 years ago, the most sacred of the duties of a government is to do equal and impartial justice for all its citizens. We hope you'll leave the evening with a better understanding of the contributions of lawyers and judges in furthering the rule of law and about the role of fair and impartial courts. Before we go further, I would like to introduce my colleagues. I will mention that I grew up in the far northwest corner of Kansas in Goodland. To my right is Justice Eric Rosen, who hails from Topeka. And I'm doing this in order of the seniority of our court, which is also how we are seated. On my left is Dan Biles, who grew up in El Dorado. Back to your left, my right, Caleb Siegel, who hails from Lawrence. Evelyn Wilson, who grew up near Smith Center. KJ Wall, who grew up in Scott City. And Melissa Standridge, another Lawrencian, I think is what they refer to themselves. So we have a good representation from Lawrence, but really a good representation of the entire state. You can tell our roots go deep in Kansas. Also, before the clerk calls our docket, I want to express my gratitude to the many people who have made this trip and our visit here possible. Certainly, a lot of people in the First Judicial District have had much to do with that. So to explain a little bit, when I refer to the First Judicial District, I am referring to Atchison and Leavenworth counties. Our state is divided into 31 judicial districts. Some are as small as one county, and many are several counties. So I would like to begin with the recognition of the current judges and some retired judges who helped us today as we visited the schools. They accompanied us. So I extend a special thanks to Chief Judge Joan Loudon, who has done many other things to help us today. Retired Chief Judge David King and Judges Gerald Puckelman, Jeffrey Sontag, Dan Wiley, John Fresh, John Bryant, and Clinton Lee. Thank you, all of you. We also thank Court Administrator Stephen Crosslet, who, along with his staff, has done a wonderful job of helping with the arrangements. Court Service Officer Tom Washer and the other CSOs, I think there's a whole group of them here tonight. The Clerk of the Court in the Atchison County, Bria Lorenz. The Clerk of the Court in Leavenworth County, Julie Clemens. And all of those in our clerk's offices, our court reporters, and all of our other employees in the First Judicial District for their help and their very warm welcome for our visit today. We are very proud of the job they do to serve you every day in your communities. I do also want to thank our staff who helped with this, the Clerk of the Kansas Appellate Courts, who you'll hear in a minute, the staff of the Office of Judicial Administration who oversee the logistics of this travel docket. This activity does take quite a bit of time and planning to make this event so successful. One final group that I would like to express appreciation to are the law enforcement officers and the security personnel who have helped plan and provided security during our trip. It seems that whenever we do these trips, all we have to do is make a simple ask, and law enforcement responds with a great effort. And tonight we have had the help of the Lansing Police Department, the Leavenworth County EMS, Leavenworth County Sheriff, the Kansas Highway Patrol, the Capitol Police Protective Services Division, and Casey Protective Services. So thank you to all of them as well. And last, but certainly not least, I want to make a special recognition to our honorary bailiff for tonight's docket. Donna Oswald. Donna retired from her employment with the Kansas Judicial Branch after she worked for 45 years in the Atchison County Courthouse. During her career, she worked as a court system as a secretary for probation, an administrative assistant for judges, and later as the clerk of the court. She has provided consistency during her tenure and led the clerk's office through some really significant changes. Judge Loudon explained why we honor Donna tonight by saying, Donna was always very careful about requesting the absolute minimal budget she could to properly function. Every piece of office equipment was used to death before a new one was purchased. But more than that, she added that Donna loved greeting the people of Atchison as they came into the courthouse and providing them the best quality service that she could. She added that Donna was also aware of the historical significance of the documents in the clerk's office. You, even better than all of us, probably understand how much of Kansas history started in these two counties. And Donna has helped with the preservation of much of that. You can see the effects of her efforts when you walk the hallways of the Atchison County Courthouse. So when Donna retired, a wealth of talent and knowledge departed with her. Fortunately, she remains available when the need arises, and we're grateful not only for her past service, but for her willingness to be here tonight for this historical evening. Thank you, Donna. And with that, we'll move on to why you came. I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the evening's docket.
Thank you, Your Honor. May it please the court. Council can approach. The first case on the 6:30 p.m. docket for Tuesday, April 23rd, 2024 is appeal number 124160, Benchmark Property Remodeling LLC Appellants versus Grandmothers Inc., Core First Bank and Trust, Kansas Department of Revenue, Robert Zabel, and the state of Kansas, Shawnee County, briefs both sides. Counsel for Grandmothers and Robert Zabel have requested 5 minutes rebuttal time, Your Honor. Counsel will enter their appearance.
Thank you. Justice of the Supreme Court, Brian Smith and Christine Kaplinger appear on behalf of the appellee petitioner, Grandmothers Inc., and Robert Zabel.
Justices of the Supreme Court, Diane Lewis appears on behalf of appellant respondent Benchmark Property Remodeling.
Second case is appeal number 125318, State of Kansas versus Javon Malik Dotson, Wyandotte County. Briefs both sides. Counsel for the appellant, Dotson, have requested 3 minutes rebuttal time. Counsel will enter their appearance.
May it please the court, Peter Meharry for appellant Javon Dotson, present and ready for argument.
May it please the court, Kayla Rayler, Deputy District Attorney of Wyandotte County, on behalf of the state of Kansas appellee, present and ready for argument.
Your Honor, that concludes our April 23rd, 2024 docket.
Thank you, Mr. Sheehan. Thank you, counsel. As counsel in the first case take their seats, I'll just add a couple of other comments for the benefit of the audience. I wanted to let you know that there will not be a break between the cases, a formal break in the court proceedings. But if you need to leave as the attorneys transition from one case to the other, feel free to do so, but please do so quietly. Second, I would like to explain to you that the justices are familiar with the facts of the case and the parties' arguments. We have reviewed the documents that have been presented to us, done our own legal research. So you may see us at times consulting our computers where those documents and our notes are stored. Please know that when we're doing that, what we are doing is really just checking on something in our notes or in a document. We do that to assist us in our understanding of the arguments that the counsel are making and in processing the argument. But we do want to assure you we are still actively listening and processing the arguments that are being made before us. So with that, I will now call the case of 124160. Mr. Smith.
May it please the court, justices, opposing counsel. I'm here on behalf of Grandmothers Inc. And Robert Zabel. And we have petitioned this court to review the opinion of the Court of Appeals as it relates to an appeal from the Shawnee County District Court. The primary issue I'd like to talk about tonight, we've raised two. The first one is that the appellate courts do not have jurisdiction to decide this issue, as the matter that was appealed was not a final judgment. The second issue that we've raised in our petition that's before the court, if the court considers it, is that the Court of Appeals erred in concluding that there was an issue of fact of whether there was a contract. What we are asking the court to do is to find on the first issue, which is that the Court of Appeals and the Supreme Court lacks jurisdiction over this appeal and therefore dismiss it. This would leave the case in the posture where there had been a motion for summary judgment ruling on a number of the counts filed against my client, and the remaining counts had been dismissed, and we would take the position that the case is concluded at this point. The time to appeal the motion for summary judgment or to conclude the case has lapsed. Let me fill in the gaps on that, justices. The case arose out of a construction. My client owns the building at 29th and Topeka, where the Kansas Department of Revenue has its driver's license operation. The KDOR is a tenant of my client. The KDOR decided that it needed some additional internal construction and sought a bid from Benchmark to perform some of the work. The dispute that was ultimately presented arose over payment and who Benchmark had a contract with. Parties presented summary judgment motions, and the trial court ultimately found and granted in our favor that of the 8 counts against us, counts 1, breach of contract, 4, 5, and 7, which dealt with the Kansas Fairness and Private Construction Act, the Public Construction Act, and the foreclosure of a lien, we were entitled to summary judgment on. In order to appeal this case, Benchmark filed a motion to dismiss its remaining counts, which would have been counts 2, 3, and 6, without prejudice. They then filed, also then further asked that the court make an order, which is before you, that all of the claims were dismissed without prejudice. My client had a small counterclaim. So the case then proceeded before the Court of Appeals with a manufactured jurisdiction. And I would suggest to your honors that the starting point for this is KSA 60-2102, which is the basis for the appeal. As the justices know, this court only has jurisdiction over specific cases. In the docketing statement, Benchmark cited KSA 60-2102 A4, that a final decision had been made in this case.
Counsel, do you agree that all the claims in this case were final as of October 2021?
I do not agree that there was a final decision on the merits. This court stated in the case of Kansas Medical Mutual Insurance Company v. Savate, SVATY, 291 Kansas 597, that the term final decision as defined in that statute has been construed to mean one which finally decides and disposes of the entire merits of the controversy and reserves no further questions or directions for the future or further action of the court. As of the time of the notice of appeal, that's not what had happened.
But as of October 2019, there were no claims that could be litigated at all after that date.
And the date you're conferring or referring to is the date the notice of appeal was?
No, the date the savings statute lapsed.
I wouldn't agree with that, Your Honor. These claims, that requires a factual determination. As Your Honors can appreciate, the statute of limitations is one that must be raised by a defense and also may be determined, requires a factual determination. So the assumption by the Court of Appeals and the assumption in that question, Justice Wilson, is that the underlying facts would establish that there could not be any other assertion of the claims that were dismissed, which were.
So you don't agree that all the claims that were raised can no longer be raised?
They were, what I would tell you is there's nothing in the record that establishes the factually that the underlying claims, which were for quantum merit or unjust enrichment, for conversion and unjust enrichment from additional work, they divided into two claims. One, what was the original bid, and then the extra work.
That's an interesting point, but that wasn't my question.
Okay.
That doesn't answer my question. Are there any claims that any party made in this case that can be litigated after October 19th, 2021?
Yes, these claims were dismissed without prejudice. There's nothing in our statutes or case law that prevents a party from filing a claim. The question is, once it's filed and the court addresses the factual and legal issues, does the court find that either the claim had been dismissed with prejudice, which these claims were not, or has there some reason as a matter of law or factually that the claim cannot be pursued when it's refiled? And that's the basis for our argument. And in fact, if you look at the case law, I think that's the case that what the courts have looked at on this. And I would refer you to it's a 10th Circuit case. It's Christina Consulting Group LLC versus Debt Paid Gateway. It's a Westlaw case, 2022 Westlaw 881575, which the court was looking at this in a similar context. And it said, generally, a party may not manufacture finality by obtaining a voluntary dismissal without prejudice of some claims so that others may be appealed. And what this court said in the prior case that I cited, which was the CAMCO, Kansas Mutual Insurance Company case, was that it's a decision on the merits. So in a voluntary dismissal without prejudice is not a decision on the merits. Meaning the case.
But the summary judgment order is still final, arguably, at least, once those other dismissed claims can't be brought back. I'm just wondering, is your position consistent with our precedent that has historically construed those jurisdiction statutes liberally to promote resolution of claims on the merits as opposed to procedure?
Yes, I think the court in the case of Smith v. Welch, 265 Kansas 868, that issue was not directly in front of the court. That's one of the courts your justices have looked at. If you look at the next case, and that was a 1998 case. If you look at the next case after that, which is Bain versus Archer, 217 Kansas 78, which is a 2001 case, it appears to me as I read the judgments or the rulings, the court begins to realize that it has allowed in that prior case a appeal to take place when there was a dismissal without prejudice. Because we have specific delineations. We have dismissals with prejudice, dismissals without prejudice, motion for summary judgment, et cetera. I don't think this is just a savings clause issue, because all that the savings clause does is allow, if you refile it within 6 months, your deadline for filing was the date you filed. That doesn't mean that there's not that the statute of limitations is run. Not at all. What it means is simply if you are trying to save a statute of limitations, there's been no evaluation by the trial court or the Court of Appeals of when would the statute of limitations begin to run on these cases or claims that were dismissed without prejudice. You don't have that before you. And that's why we've suggested that that you don't have jurisdiction, because the plaintiff Benchmark could have tried the remaining cases. After the trial court dismissed a number of the counts, there were still several counts left that the plaintiff could have tried.
But weren't they all tort claims?
Pardon me?
Weren't they all tort claims with
Yes.
2-year statutes of limitations?
From the date harm occurs, and the court, there's no finding in the record of when that occurred as it relates to conversion claims or I always forget the last one, Your Honor, the conversion and the unjust enrichment claims.
But aren't we to view all of the facts, and we know they were tort claims that were dismissed without prejudice, aren't we to view all of the facts in a light most favorable to Benchmark?
Justice Wilson, the way I look at this is you have to interpret what the statute says. The statute that confers appellate jurisdiction upon this court. And what the statute doesn't say is that an appeal can take place so long as the time limit runs while the case is pending on appeal, or so long as meaning that the claims that were dismissed without prejudice. It doesn't say that you can confer jurisdiction as you move through the case. It says that and clearly at the time of the dismissal, when the appeal was taken, it was within the 6 months. So if we're going to look at the savings clause that says if you file it within 6 months, it relates back. While 6 months into the appeal on this is when finally it would have become ripe for jurisdiction. That's not what the statute says.
Well,
The sorry.
statute says it has to be final. So whose burden is it to show the court that all claims are final in that they cannot be raised, they cannot be litigated? They're either tried on the merits or they're too late to file.
This court has an opinion that says it's the court's job to always check to see if it has jurisdiction. I would also suggest that KSA 60-254 allows a party to obtain a order of finality, that the judgment is final as to all issues in appeal. The plaintiff could have dismissed these causes of action with prejudice. And Your Honor, I see that I have ran out of, Justice, I've ran out of time.
You can continue to answer.
I've finished my
Yes, you please
So-
continue.
So the plaintiff could have dismissed its causes of action without or with prejudice. Plaintiff specifically moved to dismiss them without prejudice, meaning the plaintiff was giving itself an extra opportunity at some point to possibly assert these claims again.
May I? Yes, go ahead. But our court has allowed notices of appeal to be filed before a judgment became final since at least 1979. So why should this case be different?
Just based on the case law and the statute. It says it has to be a final decision, and it says that a final decision is one that doesn't leave any opportunity for there to be a relitigation of the lower court of cases or claims that were dismissed without prejudice. The problem with this is then when do you have jurisdiction? Is it what if they dismiss a contracts cause of action that has a 5-year statute of limitations on it, and they're not worried about the savings clause, Justice Wilson, which means once the case is decided and it goes back down to the trial court at, let's say, 2-year mark, that plaintiff now gets to fractionalize this litigation and re-add that contract. We could brainstorm and come up with multiple types of causes of action that if the ruling of this court is that jurisdiction can be conferred based on a dismissal without prejudice, then what you are most likely going to see at some point is these claims being added back in after pieces of the case are decided, and that you have a statute for that. It's called an interlocutory appeal. And the plaintiff did not ask for an interlocutory appeal. See, there are multiple avenues where the plaintiff could have addressed this very easily and not put the court in this system, in this situation. Thank you, Justices.
Thank you. Ms. Lewis?
May it please the court, Diane Lewis for Benchmark Property Remodeling. We're here today to ask this court to affirm the judgment of the Court of Appeals, which reversed and remanded the granting of the judgment on the pleadings and the granting of the summary judgment for further determinations by the district court. And I think that Mr. Smith actually said it best at the beginning of his argument, where he said that he hopes this case is dismissed. And if the appeal is dismissed, there are no more claims and the case is over. And to me, that says that we've got a final judgment here, that we have a situation where there is no chance of piecemeal litigation. As several of you have pointed out, there are no claims remaining that could be refiled, that could put us in a sticky situation where there's multiple claims that aren't resolved on this appeal. Everything is coming, will be determined by the outcome of this appeal.
I think what he's saying, and help me figure this out, is that even though we have the savings clause,
Mhm.
you know, which, and his position is that the savings clause is there to preserve the date of the original filing. That there, I wrote down what he said, there is nothing to prevent them from refiling the quantum merit, the conversion, and the unjust enrichment claims. And maybe after they file those, they would be dismissed on, you know, on a statute of limitations, but that they could still file those claims, but there would have to be factual findings and that the law would have to be applied. Well, the law would have to be applied to the facts, and factual findings would have to be made before those could be dismissed. And if that were true, how would you respond to his argument?
Well, I would disagree with that. I think we can all look at tort claims and know what the statute of limitations are and know the effect of dismissing those claims in the savings statute. But I would also point out that if we're going to take the argument to that conclusion, that we have to take it to the logical conclusion in every case. Just because a case is dismissed with prejudice, technically I could still refile it and force a court or the opposing party to file a brief to dismiss my claim because it's barred by res judicata, or it's barred by, you know, the statute of limitations, or it's barred by a prior order in another case, or it should have been filed with another as part of a different litigation. So I think that argument is always out there. I mean, anybody can file anything, and that if we're gonna you know, pretend we don't know what the statute of limitations effect would be and say, well, this could still be a final judgment, then I think we have to do that with everything. And I think where this case really is similar is with Supreme Court Rule 2.03, where if you do have this essentially is a premature notice of appeal. And it's always a tough situation where you've got a summary. My client was faced with a situation where he had a summary judgment and a motion for judgment on the pleadings. We believed that the district court got it wrong. The Court of Appeals agreed with us that the district court got it wrong, and my client had to make a choice. Do I want to pursue my main claims, or do I want to pursue some other claims I have that are a little bit smaller but are important to me just the same? And I think that puts litigants in a difficult situation. And so we dismissed without prejudice and with no intention of refiling, but that's a difficult call to make in the moment. And
For 6 months, you could have.
I could have, we could have, and I guess maybe this goes to my practice as an attorney, but it never would have dawned on me to ever pursue a claim and an appeal on the same issues. But I can certainly see how it apparently has happened in the past. And
What's your best argument? This case was filed before any briefs were even filed in the appellate courts.
what's my best what?
What's your best argument that this case, all the claims in this case were filed before any briefs were even filed in an appellate court?
I'm not sure I understand the question.
You had the dismissal without prejudice,
Mhm.
and the savings statute period of 6 months ran.
Mhm.
Was the case final on that day?
I believe so, yes.
Why? What is your best argument?
My best argument is that the statute of limitations had expired, the savings statute has expired. There is no way that a valid claim could be brought on those claims against grandmothers or Mr. Zibel in any fashion. The claims were done. It promotes the court's goal of avoiding piecemeal litigation. It promotes the court's goal of a liberal interpretation and liberal construction of civil procedure statutes to ensure that cases are tried and decided on the merits, to eliminate traps for attorneys and eliminate traps for pro se litigants. And it promotes the court's goals of resolving these cases in a logical way that promotes judicial efficiency. And I think that this, that pursuing the appeal in this way, concluding that that was a final judgment, that if anything, the notice of appeal was a bit premature, but ripened before the Court of Appeals read any brief, before the Court of Appeals made any determination on the case, that this case can be reversed and remanded, that the claims can be decided on the merits by the district court, and that we can get a full and final determination of all claims and have no pieces outstanding and no loose ends to tie up.
What?
As I understood at least a portion of Mr. Smith's argument, we don't have, it was that we don't have before us the things that we need to make the conclusions you were asking us to make. In other words, that those are usually things, including questions of fact, defenses that need to be asserted that have procedurally, that those steps have not occurred here. So how do we cure that to be able to get to a ripened a judgment or for the premature appeal to have ripened so we would have jurisdiction?
I guess I would say we do have that information, and that we've got the dismissal without prejudice that identifies all of the claims that were dismissed without prejudice. I think that we can take that, we can look at the statute of limitations, and we can look at the date of the dismissal, and from that conclude that there are no further claims that could be brought and as part of piecemeal litigation, and that these are in fact the only claims that will ever be decided on the merits by a court.
Is this really how we want the procedure to work? And that it's the court's burden to say, okay, when this, we'll talk about the Court of Appeals for a minute. Okay, Court of Appeals, this case has come to you. They do a jurisdiction check. You may not know that, but okay, there's no jurisdiction right now because this was dismissed without prejudice, but let's hang on to the case for a while and let's wait to see whether or not they, refile the case. And then before we read the briefs, then maybe they'll refile it. And then, okay, now they didn't refile it. So we're just going to assume that we now have jurisdiction because now it is final. So let's construe this as a premature appeal because, we have, the Court of Appeals has 1,600 cases filed every year. And then when we pull it up, is this our duty, our burden as the court to do this? Or is it your burden to say, okay, this is what we want. We want you, the court, the appellate courts to have jurisdiction. So we're going to dismiss these 3 claims with prejudice so that it's clear to everyone. And, what should we do with this? It's kind of like you want us to make a law out of bad facts.
And I understand that. I don't think this would be making a law out of bad facts. I think this is an unusual situation that I really didn't see replicated in any research that I could find that was really on par with exactly what happened here. So I think this would be just looking at the existing case law, the existing rules, the existing procedures, and the existing intent and existing policies of the court and the judicial system to hear cases on the merits, decide cases on the merits, and to eliminate potential traps for attorneys and pro se litigants, and look at what we've done in other cases and view this as analogous to those situations, and analogous to a situation where there's a slightly early appeal, or analogous to a situation where claims were dismissed, but they weren't refiled. So they weren't something that the court took up. And I think in the Smith case, the court declined to hear cases that were dismissed without prejudice. The opposing party wanted to bring up an issue on a case on one of the claims had been dismissed without prejudice, and the court said, no, we're not going to hear that. But what they didn't say is, well, hey, these claims were dismissed without prejudice. how do we have jurisdiction on this appeal? And so I think that there's, I think that it's not something that comes up often, and that we can resolve it consistent with the court's prior rulings and opinions.
Do you know whether the savings statute, which, after a party secures a dismissal without prejudice, generally has 6 months to refile those claims, is that statute subject to equitable tolling? Can a district court judge find that under certain circumstances, the opposing party engaged in deceptive or fraudulent conduct that prevented the party from refiling, that then should equitably extend that 6-month period?
I do not know the answer to that off the top of my head, to be fair. I know that underlying statute of limitations can be equitably told, but I don't know about.
Well, if it could be, does that change the question about finality here? That maybe it's not so cut and dry whether or not a 6-month period should, the lapse of that 6-month period should sort of mature into appellate jurisdiction.
I'm not sure I know enough about the case law to.
I have a quick follow-up on that.
Sure.
Are you relying exclusively on the idea that your dismissed claims are barred by the statute of limitations to support your argument for jurisdiction? In other words, what if obviously there was no statute of limitations problem?
If there wasn't a statute of limitations problem, or if there wasn't a statute of limitations problem, I suppose I could, I guess I hadn't thought about it in that terms, but
let's
essentially, yeah.
consider that
Yeah.
the rule, whatever rule gets adopted in this case, might
Yeah.
have to apply in a future case in
Yeah.
which we have, let's just say, a very long statute of limitations, 10 years, whatever,
Mhm.
so that no longer becomes a factor
Mhm.
in future cases. I mean,
Yeah.
do you think do you think there's appellate court jurisdiction in a case where summary judgment's granted on some claims, other claims are dismissed? No one is concerned about them being barred by the statute of limitations.
Mhm. I think in that case, there would be an argument that you wouldn't have a final judgment because you do have a claim that
So
could
my
be
follow-up
refiled.
to that
Yeah.
is why? In other words, how is that any different from the circumstance in which you had filed the claims which were ruled on in summary judgment and simply hadn't filed the other claims?
Mhm.
Is there any difference between this case and that one that I just described?
In a case where I just hadn't filed these claims,
Yeah, they just hadn't been
they
filed.
hadn't been filed. And I don't think there is. I think there's always that risk out there that you could have claimed that any party that's got an appeal could have a claim that wasn't brought in the underlying case that they could refile. And
It seems odd, at least, to think that appellate court jurisdiction might hinge on whether or not a now dismissed claim had either been filed or never been filed. And why should that matter, I guess, is the question.
yeah, I guess I would agree with that. I think that, that if there's a claim that hasn't been filed, that, I mean, we could never know.
So in light of that, it
With
strikes
that.
me that your answer to my earlier question must in fact be
Yeah.
you're not relying on the statute of limitations.
I guess I'm not relying on the statute of limitations in that regard, and that there's always conceivably a claim that hasn't been filed. And I mean, any party could have one. In this particular situation, I am relying on the statute of limitations in the sense that if we would have dismissed the claims with prejudice, those specific claims could not be refiled. And in this case, in this situation, even though they were dismissed without prejudice based on the statute of limitations and the equitable toll and the savings statute, we also cannot refile. So they are effectively equivalent, just because I've got either with a dismissal with prejudice or a dismissal without prejudice and an expiration of the statute of limitations and an expiration of the savings statute, both result in situations where my client has claims that it can never, ever refile. Now, whether there's other claims out there that aren't part of this lawsuit that haven't had their statute of limitations elapse, it would be speculation. I see I'm out of time.
Benchmark had filed one of these hanging claims after you filed those.
Mhm.
What would happen to the deal? Void?
Well, I mean, we would have had to have done that before we filed our brief. So I think that would, I don't know if you can divest jurisdiction from the Court of Appeals, but I think that would make a judgment on final, I guess, as in the cases where they
Go back
refiled.
4 to 5 claim. You know, file the development court appeal. Done.
As refiled as a new too. Yeah.
Starting to get warming up a little more to the other side of the argument about the fact that the court ought to be able to look at its own records and know everything is lined up and proper, as opposed to not knowing
Yeah.
or having to rely on the lawyers to tell us that the claim has been refiled.
Yeah.
And so now we should do something about jurisdiction. We've had cases where the lawyers wanted the answer to the question. They didn't really concern themselves that there might not be a final judgment.
Yeah. And I think where you've got a goal of circumventing the process, I don't know that you can ever create rules to prevent that, because the whole goal there is to avoid what you're supposed to be doing. So you can say, hey, do this, and you're always going to have people that try and go around it. But I think that ties back to the argument of, well, you could always have a claim that wasn't filed in the underlying lawsuit. You could always have a claim that is being brought separately. You could always have somebody that refiles a claim that's been dismissed with prejudice. And I mean, those are all, there's an infinite number of possibilities that that could make a different outcome or could cause problems with jurisdiction. But I think in this particular case, yep. Yeah. In this.
One did bring.
Sure.
And so if we're thinking about a research attorney assigned to the job doing a jurisdiction check and sort of file, oh, here are these 4 claims, they've been dismissed without prejudice. Are we really supposed to decide that, oh, well, the statute of limitations is run, so we ought to go ahead and decide this? Our file, that would require something extra. And one side or the other, they're not even agree with matters.
I think that's always a possibility with any determination or with any consideration, that there can be outlier situations. But
Are there other questions?
and I would ask that the court affirm the Court of Appeals judgment, reverse and remand this case to Shawnee Circuit Court, District Court.
Thank you. Mr. Smith, you reserve 5 minutes.
I'd like to pick up with Justice Biles' question about the filing of a cause of action while a case is pending. He may have been alluding to the case of Arnold v. Hewitt, which 32 Canap Second 500. It's a 2004 case where that did happen. And the court concluded in that case that getting back to this issue of you can't manufacture jurisdiction kind of after the fact, that to allow the plaintiffs to proceed in this fashion would render meaningless the statutory provisions invoking the jurisdiction of this court. Since a final decision must dispose of the entire merits of the case, it is impossible to conclude that a final decision has been rendered in a district court to allow appeal. there is a reason for that. And I would also suggest that the saving statute is not, you're not precluded from filing an action more than 6 months after you've dismissed it. What it does is it saves your statute of limitations if you have a case on file on time. And in fact, the saving statute 6518 says that if an action is commenced within due time, meaning you put your flag in on the filing date, and the plaintiff has failed in such action otherwise than on the merits, and the time limit for the same has expired, the plaintiff, or if the plaintiff has died and the cause of action survives, his representative may commence a new action within the 6-month window after such failure. It's to save the statute of limitations. It's not to confer jurisdiction. If I dismiss a case and the statute of limitations still has 2 years left on it, I can refile it more than 6 months after I've dismissed it, as long as I file it within the statute of limitations. This protects my client if the statute of limitations had ran after I filed the case and commenced the case, which, as your justices know, is that we commence it by filing and service. Then I have the case properly commenced. And so that is not the statute's not intended to confer jurisdiction.
I wanted to, before your time runs out, give you an opportunity to answer the question I asked your opposing counsel, which is, how is this case different from a case in which the dismissed claims were never filed in the first place?
So the way the statute's written, it only speaks to the final adjudication of claims before the court. We would have no way to know what claims were unfiled.
But doesn't that cut against your argument? Because dismissed claims are effectively identical to unfiled claims, are they not?
No, a claim dismissed with prejudice is a filed claim that has been resolved and cannot be refiled.
Fair enough, but with respect to claims dismissed without prejudice, I mean, how are they different from a claim that was not filed in the first place?
Because the purpose of the appellate jurisdiction statutes are to allow the Court of Appeals to decide all of the claims presented in that case, not claims that haven't been asserted, but all of the claims presented.
And your argument is that a claim which was filed and later dismissed without prejudice effectively, well, it becomes presented essentially.
Yes, and I was going to refer your honors to an opinion authored by Justice Stanbridge that I believe might be relevant to this analysis. And it's the case of Harrington versus City of Wichita. And it is 314 Kansas 447. It's a 2021 case. And in that case, this was where a case had been filed in federal court and included state claims, and the state claims had been dismissed without prejudice. So the question was, could the person then file those state claims in state court? And in conclusion, the court states, whereas here a federal court declines to exercise supplemental jurisdiction over state law claims and dismisses those claims without prejudice, we hold there has been no final judgment on those state law claims, and the Kansas common law doctrine of res judicata does not apply. So this court has found that a claim that's dismissed without prejudice, that it has not been adjudicated on the merit, and in fact can be refiled in state court.
So just a real quick follow-up.
Yes.
If the rule that you're advocating for suggests no appellate jurisdiction whenever there have been claims dismissed without prejudice, what would happen if a plaintiff filed a lawsuit and very quickly decided to dismiss certain of the claims that were made, perhaps even prior to the filing of an answer? So you get a lawsuit filed and several of those claims are quickly dismissed without prejudice. Then years go by, parties litigate, go through discovery. We sort of follow the track we're on, summary judgment ruling, still no appellate jurisdiction?
254 allows a litigant then to seek an order from the court finding that all of the matters have been adjudicated in the case. That didn't happen here. That's the purpose of that.
So you think that would require an interlocutory appeal? Is that what
Pardon me?
are you saying that that would require an order for an interlocutory appeal?
So an interlocutory appeal is not what was taken in this case.
Right.
This was.
I'm just trying to figure out how you would articulate appellate jurisdiction in my scenario.
So in your scenario, what I believe a plaintiff should do at that point, if so the case proceeds forward, if I understand under your example, the claims that are dismissed aren't ever brought up. Let's assume the case is tried. Then it's been decided on the merits.
So I don't understand how the rule you're asking us to adopt would be articulated, because it sounded to me like from your earlier argument, if there had been a dismissal without prejudice at any stage of litigation, even very early on, that would deprive any appellate court of subsequent jurisdiction.
I think you articulate the rule and follow the statute, which
Well,
says that it has to be a final decision on the merits, is what this court has said. And it's not.
And you're advocating that anytime there's been a dismissal of any claim without prejudice, the resulting adjudication of the remaining claims are never final. That's what I understand you to be saying.
And that's why I'll finish it. Yes. And that's why we have a statute that allows for a litigant to ask for a ruling from the court that it is a final judgment as to all of the claims. There's protections. This plaintiff had multiple options to choose. What this plaintiff chose to do was dismiss without prejudice and appeal.
What if the district court declines to certify it as a final judgment?
Yes, you have case law now where they have declined to find that the court did it properly. They send it back down. Your honors have sent these cases back down for the court to make the proper findings. And you know how that can be fixed. The plaintiff can agree to dismiss those cases with prejudice. There's multiple, the rules already have plenty of options for a litigant to choose from if they want to try to finalize a judgment. They can either ask for an interlocutory appeal, they can dismiss with prejudice, they can ask for a 6254 final ruling, they can try the claims and get a judgment.
You know what I don't understand is the disconnect for me is that you keep talking about a final judgment on the merits, but let's say that it goes back down and the judge, you ask for a final judgment and the district court dismisses with prejudice. That's not on the merits. They're not deciding the merits of the claim.
A dismissal with prejudice has to be a finding by the court. The court's
not, the court is saying, this is dismissed, but there are dismissals that are not, for example, like a statute of limitations. You dismiss and it's a final judgment, but that's a procedural issue. That is not on the merits. So I could have a great claim, okay? And on the merits, I'm right. I mean, this was a giant truck that hit, this person and the truck driver fell asleep and this is a meritorious claim, but I waited, 4 years to file the claim instead of 2. And so it's kicked and it's dismissed and you can't refile it because you blew the statute of limitations. That's not a final judgment on the merits. It's a final judgment because you blew the statute. So you keep talking about on the merits, but I'm not getting it.
I would suggest to Justice that a finding that the statute of limitations has expired is a finding. The legislature has established. It's a finding of fact. It's a finding on the merits. It's a fact. The legislature, certainly the legislature has determined that there are limits on when you can file a claim. That's why under 6513, which is the statute of limitations for court cases, that's why there are 446 cases that cite to that statute, because when the statute of limitations accrues and when it runs, it has been hotly litigated for decades. And it is a factual determination and it can be waived if it's not asserted. That's in the case law. It can be waived if it's not asserted, and it is a factual determination. And so, yes, it is on the merits because what the legislature has, I would suggest to your Justice that it is, because what the legislature has determined, which is that a claim no longer has any merit after it's so many years have passed since the harm or injury occurred. Just like the statute that confers appellate jurisdiction says it has to be a final decision, on the merits. And so I would suggest that the statute of limitations decision is in fact on the merits. The merit is you have to have a valid claim, right? And is it still a valid claim? Then you have to prove that there was a duty and a breach of the duty.
Right, I understand your position. Let me ask one more question. So, what you said kind of triggered something for me, which is, do you agree or disagree? Do you believe that the statute of limitations, if you blow the statute of limitations, is that subject matter jurisdiction? Or there are exceptions, correct? Well, there are exceptions to it, right?
So then is it a 6212B, like lacks subject matter jurisdiction, failure to state a claim, those types of things?
Basically, I'm asking, when you're talking about, so for example, that could, if the statute of limitations here was a year, okay, and the saving statute goes by, and then now there's you blew the statute of limitations. You can't file this action anymore. But there are exceptions, right?
Sure.
Like
Fraud. If
fraud, right? I mean, there are certain exceptions.
Disability, if the person was
Right.
a minor, yes.
So just because that 6-month window passed doesn't mean that it couldn't be refiled, right?
That's correct.
So that's your position.
And in fact, if the defendant didn't raise the statute of limitations as a defense to place it in front of the court to be ruled upon, that's the court's job, then that case would proceed possibly to a final judgment on a case that the statute of limitations has run.
I think I understand your position.
Thank you for your time, justices.
Thank you. Thank you to both counsel for your arguments this evening. The court will take this appeal under advisement. I will now call case number 125318, State of Kansas versus Dotson.
May it please the court, Peter Meharry for appellant Javon Dotson. This case comes before this court after two friends got in a verbal argument that unfortunately escalated into a physical fight over a gun. That fight left one of the friends dead and my client charged with first-degree premeditated murder. He was ultimately convicted of that charge and sentenced to life in prison. Below in the criminal proceedings, there are what I would say two major issues. The first one being self-defense, whether or not self-defense applied in this case. Then the second issue I believe was important was whether or not there was any evidence of premeditation. The issues that we've raised in our brief, at least the first few 3 or 4 issues, address those key issues. And what I'll start with is the prosecutorial error issue, because I believe that does touch both of those issues. We believe the prosecutor in this case, in closing arguments, made misstatements of the law as far as self-defense, and also improperly diminished what was required for premeditation. During closing arguments, the prosecutor repeatedly said that if you start a fight, you don't get a claim self-defense. While self-defense may be more limited if you are the one who starts a fight, or otherwise the initial aggressor, it is still an available defense. But the state painted a black and white picture for the jury as to those two doctrines. And they said
Let me
they are
ask you
mutually
about that. I'm
exclusive.
sorry to interrupt your argument, but I'm not so sure that's completely the way I read the record. And you tell me if I'm misreading it and why. Because the statement, "you cannot claim self-defense," was said, but immediately preceding that, the prosecution explains the jury instruction, including the requirement for initial aggressors to exhaust reasonable means of escape. Then says that didn't happen here factually because there was reasonable means of escape. Then makes the comment that you're challenging here. I'm just thinking, when you put that in context, why isn't that an accurate statement of the law as applied to the facts as the prosecution viewed them here?
The problem is the prosecutor does at times say you have to exhaust reasonable means of escape, but it always goes back, prosecutor always goes back to that quippy line, if you start a fight, you don't get self-defense. That's the fallback. And that would mislead the jury into believing that they are mutually exclusive. And that's something I believe the state conceded in their own brief. If you look at page 8 of their brief, the state says the jury either believed that Dotson was the initial aggressor and self-defense did not apply, or they did not find Dotson credible and did not believe self-defense applied at all. The state is saying the jury was misled into believing if he's the initial aggressor, self-defense does not apply, and that is not the law in Kansas. And in this case, self-defense was the main issue at trial, and it was critical for my client that the jury fully understand how to apply that defense to the facts of this case. And the state's comments misstating it were critical and prejudicial, and we believe warrant a new trial in this case. Additionally, we believe the state improperly diminished what was required for premeditation. In this case, the state said in closing argument, it's just more than instantaneous. The state talked about how it's no big deal, that it's just more than an instantaneous killing. And we believe that that is watering down premeditation such that it is basically no different than an instantaneous killing or an intentional killing. So we believe those comments go to two critical aspects that were heavily litigated at trial and improperly led the jury away from properly applying self-defense and properly considering the evidence in support of premeditation.
How is saying it's more than instantaneous watering down the standard to instantaneous?
Because when you're saying it's just more than instantaneous, I think that's saying it's basically the same. That's what you're conveying.
Can you help me syntactically, as a matter of, I guess, definitionally, that's not what it means. I mean, the word more means something in addition to. So help me understand your argument that saying more than is actually just saying, no, it's just instantaneous.
They're saying it's, quote, just more than instantaneous. And that would give the impression it's fractions of seconds.
So is it the word just that you are objecting to?
That is part of the problem with this comments the state made in this case, Your Honor. In addition, it talks about how it's no big deal. It's not like Hollywood. You don't need to show a plan. We believe that what the state was conveying was something less than premeditation is required to convict of premeditation. They're watering it down such that any intentional conduct by my client would suffice to find premeditation.
I thought the argument also, and maybe this comes from the pro se briefing, but the argument was that the focus exclusively on the temporal element of premeditation without discussing or acknowledging the cognitive component, that it's not just about time, it's about time for thoughtful deliberation. That's that there are two components, and by never acknowledging the second cognitive component, that this case is sort of like our Coleman decision. Is that part of your argument that has been briefed and preserved for our review?
I believe, to the extent the state is only talking about the time element, I believe it is like Coleman, where this court talks about how it focused on time, and it's watering it down, as I said, that it's limiting, so it takes basically next to nothing as far as the time element goes to show premeditation.
Are you saying that anytime the prosecutor talks about the temporal element, they must also talk about the cognitive element in the same conversation? You're saying they can't split those two things up?
I don't know that I'm necessarily saying that. What I'm saying in this case, the prosecutor was watering down the time element to next to nothing. Certainly.
So that, just to clarify, that sounds like you're, when you were answering Justice Wall's question, what you're saying is you really are just focused on the time element.
In this case, I am.
Okay.
Because it's the comments about it's just more than instantaneous, it's no big deal, stuff like that. They are saying it doesn't take any time. Premeditation can be in an instant, and that's what they're conveying to the jury. And in a case where we're arguing that there's insufficient evidence of premeditation, that was critical and certainly prejudicial to my client's defense. Because in this case, the evidence, as I mentioned at the top of my, I guess we'll call it a speech, was that this was a fight over a gun. It ended when my client was able to wrestle the gun away, and the testimony from the state's witness was he immediately shot. No hesitation, no thought process. He immediately shot once he was able to get control of the gun. We believe that the timing and what the witness said shows that this was not a premeditated murder.
Typically, the shooter is firing more than once. Those second, third, fourth shots are often seen as evidence of premeditation.
This court has looked at other cases and said, you know, the number of shots or the number of stab wounds can be used to show premeditation. That is this court's case law.
You're dead from first two very quick shots.
That was the testimony at trial, Your Honor.
Why can't we look at, regardless of whether two shots to the groin later or the fatal shot or the previous, why isn't that corroboration of premeditation?
Well, first I would say you have to look at, this court has said, actions and what led up to the homicidal act. And it has to be conscious deliberation before the homicidal act. That's what's required for premeditation. And when you go down the road where you're going to say, okay, we're going to look at what happened after the fact, I think you go down the road of making anything that's intentional suddenly premeditated. There was no indication prior to the initial shots that my client had any plan, any intent to kill prior to those initial shots. And the fact that he shot him again after the fact, I think shows more evidence of an individual who was just involved in a fight for his life and probably having a lot of emotions and rage, probably because they were in a fight, such that he shot him again.
We would call that emotion rage part of the cognitive process. Why would they put somebody through there?
Well, I don't think there was any question that the first shots were fatal. The testimony at trial was once those first shots were made, the victim did not move. He was dead. It was clear. So actions after the fact, I don't think somehow go to prove some sort of premeditation before the fact.
Well, the coroner's evidence suggests that, I mean, it's possible the victim was still alive at the time those last shots were fired. As I recall from the record, the coroner testifies that definitely those were the fatal shots, but it would have produced death at the longest 2 minutes. And then the victim's mother testified that those final shots came 1 to 2 minutes after the first set of shots. So these second sets of shots, the victim might have been alive. Does that matter? Or does that change the analysis
Well, I would
on
say,
a sufficiency
Sure.
challenge?
I would say two things. Number one, the testimony also was that those initial shots would be immediate incapacitation. And I think secondarily, the testimony from the eyewitness was that he did not move. Her testimony was bam, bam, on floor, dead. That was her testimony. So I don't think you can say or look at additional shots to show premeditation in this case, given how it played out and what the testimony was.
And if I can just ask one final follow-up, I know I'm taking up a lot of your time here, but I asked the question, Justice Stegall followed up, and I'll just ask one more time. In your 609 letter to the court, you cited Coleman, and I just want to make sure that that citation is in support of your argument as to prosecutorial error regarding minimizing only the time component of premeditation.
That was the argument we raised, and that was a similar argument that was made in Coleman. So that's why I 609 it, is that in Coleman, they diminished the time element, and here we think the state did the very same thing.
But not the cognitive component.
No,
Okay.
I don't think there was any evidence of any cognitive element in this case, which is obviously why we're arguing sufficiency in this case. So for those reasons, I would ask that this court reverse this matter. One thing I would, I guess, this is a little different ask than I usually have. We believe there's insufficient evidence for first-degree premeditated murder. Even if this court believes that a new trial is warranted because of other errors, we believe it still must decide the premeditated murder issue. And if it does find insufficient evidence, remand it for new trial with the top charge being murder too. Thank you.
May it please the court, Kayla Rayler on behalf of the state of Kansas. There was sufficient evidence to establish that Dotson had completed the cognitive process to form his premeditation prior to killing RJ when he was standing over him. The evidence at the trial through the testimony of Ms. Marks was that Dotson lunged for the gun, grabbed the gun. That is when RJ grabbed for the gun. She sees this struggle over the gun. She runs to her bedroom to get her gun from under her bed, runs back out, gets knocked in the head by Dotson, leaving a goose egg on her head, causing her to lose consciousness, gain consciousness again to see her son and Dotson move from where she saw them last to down the hall, fighting over this gun still. Dotson pushes RJ into the wall and RJ loses his grip on the gun. He falls to the ground, and that is when Dotson decides to straddle over RJ, pointing a rifle at RJ and shooting him in the chest.
Well, that's not what the record said. The record says that it was instantaneous, the first 2 rounds, that as he was falling to the ground, the shots were fired, at least the victim's mother, and it was as fast as, I think she clapped, instantaneous, right? And then there's this pause of a minute or two where then the evidence or the testimony is that Mr. Dotson stands over the victim and fires the additional rounds. Am I wrong on the record?
If I may have a moment I have the record in front of me. I believe I have it tabbed, if I may have a moment to look.
Yeah.
So what I read in the record is that the way I read the record is that RJ's up against into the wall and it's like an instant second, bam, turn around. He hits me with the gun close enough that it only took one step, loses consciousness, gains consciousness again, slams RJ into the wall. He was limp. He turned the gun and said, I'm looking if someone hits you in the face, I'm looking dead at him. If I hit you in your face, you're gonna remember because you're gonna see him hit in his face. She passes out. There's nothing from what I read in the record, and I may be mistaken, that he said that the shooting was instantaneous with him hitting the wall after she regained consciousness. The instant I read in the record was when Mrs. Marks got hit in the face.
Could you help me here? We, as a court, frequently, it seems as of late, are getting a lot of cases regarding the distinction between an intentional killing and when that becomes premeditated. And everyone here thought, even counsel thought, the judge thought that this was a very close call on that distinction between something that is intentional and then the line gets crossed or becomes a premeditated act. Tell me what you think in your words. When is that? And I asked that at our last docket, and it is a frequently asked question. That it seems like there isn't lately an intentional murder that clearly fits under second degree that also isn't premeditated. So help me here why this fits and a scenario where it doesn't. Where is an intentional murder not premeditated? Because there's a distinction and a big one, I think, and intended to be a big one, in all aspects.
I agree. There is a distinction between intentional and premeditated first degree murder and second degree murder. My position, if I were trying this case, was the minute that Dotson lunged for that gun when there had been no weapons introduced prior, showed his premeditation to kill. I believe if I were trying this case, that's when I would have argued that the premeditation had been formed, but it continued. It continued through the struggle over that gun.
Why isn't that just, I'm going to intentionally kill this guy? Why is that? Why is lunging for a gun establishing premeditation rather than intent? I mean, we have it.
Because what?
Go ahead.
Not to sound flippant, but why else would you go for a gun but to kill somebody? That's what we hear in the community significantly.
He intentionally killed him.
But he's lunging for the gun for the purpose of killing him, which would be a cognitive process that had reflection. And so he could carry out that premeditated thought. But it wasn't just him lunging for the gun. It was the continued fight over the gun where he had the opportunity to reflect on what he was going to do when he got this gun. And then what he did when he got the gun. As Justice Wall indicated, the coroner indicated the victim could still be alive after 2 minutes of being shot the first time. Those second shots could have contributed to his death even quicker because he could have still been alive. Nobody checked his pulse after the first shot was fired. The coroner's testimony was after 30 seconds, he would have lost consciousness because of his blood loss. So there's still that reflection after those subsequent shots were fired that I intend to kill this person. But in addition, to go back to your first question about the distinction between premeditated first-degree murder and an intentional murder, I would argue that there are several factors that you would have to look at that this court has indicated when it comes to premeditation. For example, if a gun has been modified to be an automatic weapon, I think in those situations, you could make an argument better that that is more of an instantaneous killing because you don't have to go through the motion of racking around. You don't have to go through the motion of continually pulling the trigger. You don't have to go through that thought process because it has been switched from a semi-automatic firearm to an automatic firearm. And the evidence in this case was that it was a semi-automatic firearm. So he had the opportunity to stop after the first round. He did not. He chose to and made the decision to fire a second round to ensure that his victim was going to die. So I think you have to look at the facts and circumstances of each case to make sure there is sufficient evidence of premeditation. And here you have it based on the defendant's entire course of conduct during this fight. That kind of goes to the claim of prosecutorial error with regard to the temporal element. If I remember correctly from reading the prosecutor's closing argument, he did say, it was either in the rebuttal closing or the first closing, I apologize, I can't remember which one, either the first prosecutor or the second prosecutor talked about all the decisions he made before taking a life. And then the second prosecutor talked about the temporal element, that it has to be more than just an instantaneous action. Hollywood does make pre-med out to be something that has to be thought out, written down, documented. I have to go to a store. I have to go get cleaning supplies. I have to figure out what I'm going to do afterwards. And his argument is more trying to relate the law to everyday real life, that a plan, a list, a to-done list is not required. A to-do list is not required. It is, I thought, I did. I thought about it, I reflected on it, I did the action that I thought and did. It's like your example in State v. Stanley, eating a cookie. I have a craving for a cookie. I decide to go get a cookie, or I'm going to be good on my diet and not go get a cookie. But if I just go over and reach for a cookie without thinking about it, that would be an intentional, not a premeditated act. The example I use in jury selection is going out to eat. If I go to the local Taco Bell and I go to the drive-through because I'm really wanting Taco Bell, I see the line is out, it's 20 cars deep. The next thing I know, I'm going to Wendy's. I don't even think about not going in because I saw the line. I didn't process the risks and consequences. I just turned and made that decision. Whereas if I decided to have Taco Bell, I would have reflected upon my decision to risk being late back to court versus I really want my Taco Bell. So that while it's not exactly on point, I think that's a good analogy to kind of explain the difference between intentional and premeditated murder.
But when you say it's just more than instantaneous, isn't that a little confusing to jurors, because that whole cognitive processing element, how is that captured in a statement like that? That it just has to be more than instantaneous.
I think it is difficult to capture that cognitive processing element, which I think goes to some of the questions that were alluded to. Is the state required to put them both in the same sentence or the same portion of their argument, or can they parse them out to explain the difference between the two? Because it is difficult to explain how, without a psychiatrist on the stand to explain the processing power of the brain, how do we get those facts and evidence so we don't commit error in closing to explain how quickly cognitive processing can go? I think that while it sounds like it's trying to quantify an amount of time, I think it's more just explaining that it's not instantaneous. It's just something more than instantaneous, which this court has said it's not instantaneous. So my position would be that that's not a misstatement of the law, and it's not watering it down or diminishing it, because I believe in closing, both prosecutors talked about the decision-making process of this defendant during the course of his actions. With regards to, we didn't address it on the first part of the argument, but the Stanley instruction issue, we would ask that you follow the law that has been the law in the state of Kansas for over 20 years. Premeditation is already defined by Pick, that the Brohard instruction and the Stanley instruction are more than just what is required. While they may be helpful to some juries, it could create some confusion to other juries, especially if they're not given, unless this court wants to change its position on requiring that it be given. In State v. Stanley, this court said that the Stanley instruction should be given if a Brohard instruction is given. Neither were requested in this case, and the court did give the standard PIC instruction for the definition of premeditation. Unless there are any other questions, I will stand on my brief.
I see no questions. Thank you.
Thank you.
I would argue that if going for a gun is premeditated murder, that makes every murder committed with a gun in this state premeditated murder by default. And that's the problem. What they're talking about are intentional acts. And they're blurring the line such that there is no difference between premeditated murder and intentional murder. The legislature has made a difference, a big difference. My client faces a life sentence because of that.
Do you have any, and I know this is not in the record, but I guess, I mean, it might be helpful to know, do you have any, is there any data that suggests defendants are no longer being convicted of second-degree murder in Kansas?
I don't have data, and I can say anecdotally, I get a ton of first-degree premeditated murder cases, and they usually give second-degree intentional. And off the top of my head, I cannot think of one where they come back with second-degree
So
intentional.
the reason for that question is it just strikes me that these sort of hypothetical, I'll call them logic puzzle type arguments, because that's really what it is. You're making a logical argument about definitions. What it really elides or leaves out of the justice process is the jury's decision making. So if a jury is properly instructed in the law, it's really not up to us to say, well, logically, you should have done this or that or the other thing, is it?
I think the problem here is that this court has to be able to say, this is premeditated murder. This is intentional.
We have said that. We have a very clear definition.
I would argue the definition is not clear
But-
because everything becomes premeditated
I
murder.
understand that's your argument, but
I mean,
again,
it's-
I don't know how you sustain that argument without, data that suggests in reality, second-degree murder as a conviction has gone away.
I would argue to this court, this case is a good example of the problem with premeditation in this case. The testimony that I'll read to you is from the victim's mother. This is an eyewitness, and her testimony was, one quick movement, bam, hit you on the floor. It's not like you can break it in pieces. There was no pause. It was bam, 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 hit on floor dead. Question, and no pause. It was one quick time it happened. The first shot, yes.
Well,
That's from volume
That's
14.
true, but on the flip side, the state was able to present a number of decisions or things that happened leading up to that. And then you submit it all to the jury. And that's kind of the heart of my question is, I understand there's evidence in favor of intentional rather than premeditated. And then there's evidence that might favor premeditation. And our system suggests that so long as the law is properly explained to the jury, we give those questions to the jury. And it just seems like and again, as Justice Rosen said, we've had this discussion several times now. It strikes me that it's an effort to take that question out of the jury's hands.
I would disagree it's an effort to take it out of the jury's hands. I would argue it's an effort for this court to draw lines so the jury can properly apply the law. You can't just say it's up to the jury. We're supposedly a nation of laws, right? That means this is premeditated, this is not.
Do you
And
have
that's
a proposed alternative definition of premeditation you want us to adopt?
I would think there are a couple, and I've cited to them in my brief. I believe the Webster's definition where it talks about a plan and showing evidence of an intent to carry out that plan. I also believe that the Stanley instruction does go towards that end to say, look, premeditation, you have to show he decided to do A and he took steps toward that end. And I think that's what's missing in the way we talk about premeditation in cases right now. It's just intentional. And I know this has been a discussion among this court and my office before. I'm going to reiterate it. There is no difference between premeditation and intentional as it's defined by this court and applied in this state.
I'd like to go back to what Justice Biles asked about earlier. And the thing is, at the trial, it is the state's burden to prove beyond a reasonable doubt that cognitive part, what's going on in the defendant's head and when. And you've been talking about the moment from when he gained control of the gun to when he fired that first shot. Ms. Rayler was talking about, no, I think it was a longer period of time. I think his cognitive intent, premeditation plan to kill started before he gained control of the gun. And at the appellate level, we have to look at the evidence and say, okay, could the jury have taken these facts and inferred this cognitive element? Could they have? That's how we look at it. Justice Biles made a comment about not the moment between the control of the gun and the first shot, which was essentially the kill shot, but the next shot, the shot to the groin, when he was standing over him and he shot his groin with an AK-47 rifle. That didn't kill him. According to the record, that didn't kill him. But does that, what's your best argument that that doesn't support a rage that started before the defendant gained control of the gun?
I don't think it shows premeditation because, number one, it is after the fact. I know you want to take it and say, well, does it show something before the fact? And I don't think you can break up this argument that was between these two individuals. If you're going to say premeditation can come during the act,
During the fight,
that I think undermines this idea that premeditation has to be beforehand. You're saying you can form premeditation as you're doing it. And I don't think that's what premeditation means. So I think you have to look at something before fight in this case to say that.
Before he lunged for the gun, he had to form the intent to kill him?
I would argue yes. I don't think you can form premeditation during a fight. I know this court has case law that says otherwise, but if you allow that, again, I go back to the argument, it's just intentional. That's all it is. Thank you.
Thank you. Thank you to both counsel for your arguments this evening. We will take this appeal under advisement. Those in the audience may have heard me say that after the first case as well. So let me explain a little bit about what that means. And what I mean by that is that the next step is that the court will meet and we'll discuss the issues that have been argued to us today. We will make preliminary decisions about the outcome of the case. And there are in both cases some issues that were not raised in the arguments today, so we will consider all of those. One justice will then take a lead in writing a decision that will then be circulated for review by all of the other justices. I often tell students, this is like having your final graded by 7 people with a very sharp red pen. So after that occurs, and we reach an agreement about the wording and the outcomes in the case, we may all 7 agree on all parts of it, in which case it would be a unanimous decision. It may be that all 7 of us agree on the ultimate result of the case as to whether or not the decisions of the lower courts should be affirmed or whether they should be reversed. But we may disagree on the way in which you get to that final decision, in which case there might be one or more separate opinions that are known as concurring opinions. But it may also be that we disagree with each other on that ultimate outcome. And there may be one or more dissenting opinions that will be filed with that. Once that entire package of decisions or a decision is reached, it will be put into a final form that's published. Eventually they get into bound volumes, but initially they are filed electronically and will be available on the kscourts.org website. All of our decisions are there for no cost. Any decision that you hear about from the Kansas Supreme Court, you can find on that website and you can read the decision. One thing that sets the judicial branch apart from decision makers in the other branches is that we do give you the reasons for our decision, and we do that in writing usually. At the same time that we file that decision, we will have a press release that announces that the decision has been filed. And so hopefully that will get picked up to give you some information make you aware that that decision of the cases that you have heard tonight is available for your reading. So once again, thank you for coming this evening. We hope you found this of interest and that you do have a better understanding now of how an appellate court works. We invite all of you to attend the reception that will be held in the gymnasium. Will take us a few minutes to get there, but we'll be down to visit. We look forward to greeting you and visiting with you there. At this time, court is adjourned. All right.